Dear friends, dear colleagues, dear guests, dear hosts, let's begin our round table. Before we do so, I'd like to make a couple of comments. The subjects we came here to discuss are unlimited. And I think probably 50% of the round tables, at least 1/3 of round tables here have to do with the first results, progress, hopes, and prospects of the civil code reform and modernization. That is why it is quite inevitable that the speakers will probably have to focus on a whole array of different issues. I wouldn't like to restrict them. On the contrary, I'm very grateful to them for choosing such a range of subjects for their discussion. Allow me now to make a couple of introductory remarks to be able to probably focus on bigger issues related to the civil code reform. On the 30th of November, we'll be celebrating the 20th anniversary of the first version of the civil code. You know that the work was over in 2006, and in 2008 and 2009, civil code reform was embarked on, and that reform has not been completed. Because it is broken down into individual parts, the civil code draft, which will have to be adopted by way of reform, has not been adopted yet. 7 laws have been adopted, 3 more will have to be passed, and some of them are critical. It makes sense, therefore, to discuss what our work comprises. Very briefly, let me outline 4 issues I'd like to emphasize. Yesterday, the Association of Corporate Lawyers had a conference on approximately the same, the first results of civil code reform, and they made very positive remarks, gave very positive feedback about what the reform had achieved. But unlike them, I'd like to focus on some sensitive issues, touch the nerve. What has the reform demonstrated? The first question, which is probably the most dramatic and essential, is about what is to be regulated by the code. Why am I bringing this up? Because when the civil code was in the process of adoption, we partially resolved the issue of land. It was not a consistent resolution. We agreed that the issue of land ownership was divided between civil law and land law, the way it existed in the time of the Soviet Union. And now we are trying to move away from this dual nature and have land regulated by the civil code. Whether we'll succeed in doing that or not is hard to tell. This part of the civil code has not been adopted yet. Another question, or issue rather, is that unfortunately our civil legislation is not impeccably built. An attempt to create a whole system of civil legislations was made when the first part of the civil code was adopted, and at that time something unusual was done. More than 20 federal acts were named, the acts which had to be adopted in order to create a complete, coherent system of civil laws. That is something that was never achieved. Now, there have been numerous amendments which have been introduced to change the civil code and change the changes in the civil code. The land code, which has been around for less than 10 years, only had 103 articles at the beginning. It has been amended more than 70 times, and each time the amendment had the status of federal law. The same thing is going on in the realm of civil law. What can be done to bring it to an end? Different views have been expressed, including a revolutionary view expressed by Chief Justice of the Constitutional Court, Mr. Zorkin, who said that it is high time to try to make our codes, develop our codes into federal laws. Another related issue is that society and the business both are fragmented by the income level and property level. Our business is mostly oligarch type business, it's big business, and that predetermines the situation for the parties in civil proceedings. The issue of protecting the weak party has been and continues to be unregulated and unresolved. And finally, issue number 4 has to do with investment climate or investment environment. The civil law has to contribute to the development of attractive investment climate within the country, and consequently an issue which will be discussed tomorrow is an issue of free contract. But investment climate is not limited to that, because it includes civil legislation, stability, its flexibility, its adaptivity, its predictability, if you will, and that's another essential problem which has been discussed on a continuous basis and which has been resolved differently by different experts. And that is a very, very short list of our concerns. And that is not to say that all of you will have to focus on that, but we'll be very grateful to you if at least some of you agree to touch upon what I have listed. Let me tell you at the outset in which order you'll be speaking. Professor Sukhanov will be the first to speak. He'll be followed by Mr. Varul, then Mr. Mikhaeva, Mr. Berling, and Mr. Yegorov. Yevgeny, you have the floor. Thank you. My dear colleagues, I'd like to speak about the reform of Chapter 4 of the Civil Code, in other words, about legal entities. This reform has taken place, even though there was a time when we felt we were too tired, and you know that law number 99 was signed on the 5th of May. Let me tell you up front that the final product, if you decide to compare it to what we started out with 5 years ago, the final product doesn't, let me put it mildly, meet our expectations. And this outcome is pretty controversial. Let me explain to you why it is controversial. Of course, it does contain some positive elements and achievements. If you go back to what Aleksandr mentioned, 2 big achievements of our new version of the most recent Civil Code draft is the restoration, bringing back corporate law into our private law, and that is something that we didn't have, or rather which we ignored and didn't have anyone to focus on that. We used to refer to it as cooperative law or kolkhoz law, and now we realize that actually it's corporate law is part of civil law. It was mentioned in 2012 in the new version of Article 2, and now Article 12 is very clear, giving a definition of corporation, traditional division of legal entities into corporations and unitary organizations, because corporations, they dominate, and in the entrepreneurial area you only have corporations, you don't have any unitary entities. You can't find them anywhere in developed countries, not even in Eastern Europe. They don't have any unitary entities. as a legal entity which is not known. And that was the first thing that was achieved. And another thing which we are expecting soon is the restoration of property law in its traditional way. It's not ownership law, it's property law. Those are two fundamental areas of civil law which have been restored. And another thing, many of you know that the final version of Chapter 4 has been heatedly discussed over a whole succession of years. There was a lot of resistance to American approaches. Let me be quite frank with you. This resistance was coming from the Ministry of Economic Development and the working group and business lawyers. So as a result, we had to adopt some compromises. Not just compromises, our opponents managed to achieve a lot, and they managed to include into the code something that will make our life pretty difficult, because we were raised differently in a different coordinate system. So the compromises which we had to adopt are not making us happy. Because I'm pressed for time, I'll give you several examples. The division of corporations in public and private. You know that was borrowed from American law, and it's not joint stock companies which are developed into public and private. It's commercial corporations. Joint stock companies may be public or private, but private corporations include limited liability companies. It was done deliberately to expand the range of corporate contract, shareholders agreement area and apply them to limited liability companies. Why so? Because traditionally there have been two different approaches: European approach, civil law approach, and the common law approach. What is the European approach about? It's that if you have either partnership or a company, if the entrepreneur wants and is prepared to risk his or her assets, he or she may be rewarded for that. He or she can create a partnership, and for that he will receive tax breaks. They will only pay a tax once, because those partnerships are not legal entities within the realm of civil law in Europe. They are within the commercial law, so they don't pay taxes more than once. There's no charter capital standards and free internal organization or structure. It doesn't affect the creditors. Any person is responsible for the partnership and can be responsible for the debt. If the entrepreneur, if the businessman doesn't want to risk his or her assets, they can create a shareholder agreement or limited liability company, but he or she don't get any tax breaks. They should have meet the charter capital standards, and the organization is prescribed by the law. That is done for the sake of minority shareholders and creditors. The American approach is different. You realize, and that is something many people don't want to know about. A common law doesn't make any difference between shareholders companies or limited liability companies. They have limited company by share. And those may be public or private. And there's no difference, at least there was no difference prior to 2006, between what we refer to as shares and units. Under our law, shares and units, shares of a shareholder joint stock company and units within the limited liability company are two different things. Shares can be freely traded on stock exchange, and the units can only be sold in some exceptional cases, extreme cases, if a participant dies or in something else. In the American system, the word is the same, a share, and since 2006, under the English law on corporations, they've been referred to as stock, and they're different. It's different than shares. But in general, shares can be traded in the stock exchange, then it's a public corporation, or they cannot be freely traded, then it makes a corporation private. The public corporations are regulated very rigidly in the United States, not only by federal or state laws. They are regulated by the Commission for Exchange and Security Commission, CSC, and the penalties for violating those rules are very harsh. In the UK, they have a Bribery Act, and in the United States, Oxley Act, the Act of 2002 that was adopted after the Enron scandal. They introduced very tough reporting system for public companies and administrative and criminal penalties for any attempt to tamper with accounts or records. So public corporations are regulated very harshly, and our economists accept that for the United States. Private companies are regulated much freer. There's no standards for rigid internal structure, and that leads to the question about what should relations be between investors, shareholders, and the management. That is regulated by the corporate agreement. You have two different systems, and it is quite clear that our economists want to bring in the American system. We believe in the European system, and once again we seem to be having a hybrid. In the past, we used to have closed corporations, which are private limited companies, shareholders companies which were closed by shareholders. In parallel, there were a limited liability company which doesn't make any economic or political sense. So we have got rid of closed companies, and now we have private corporations, which are a new version of a limited liability company. You can look at the code and see what it writes about such corporations. Why was it done? It was done to make sure that non-public companies, limited liability companies, subject to the unanimous decision of the participants, you can include a provision in the charter to delegate to the company, to its management, the issues which in the past had to be decided by the participants. And instead of the board of directors of the management board, the management will be allowed to do that. As for general meetings, those may be held differently than what is prescribed by the law, or implementing regulations, and the same goes for the meetings of management bodies. So it introduces complete freedom, and the limited liability company law provisions, some mandatory provisions which introduce the management structure, develops into discretionary requirements, because now you can do whatever you want. You're not mandated to meet those standards. There are some individual limitations, but those limitations are the result of a compromise which was achieved as a result of heated discussion that I mentioned at the beginning. Discussions we had at my working group with the Ministry of Economic Development. Without those heated discussions, we had had more problems than this Act on Economic Partnerships. That's a benchmark for the Ministry of Economic Development, and everything they write about managing a partnership, they wanted to translate it, to transform it into a general standard. Luckily, they didn't do that. We managed to introduce Article 67.2 of the Civil Code, which contains some limitations, but there are not many. And this agreement on private corporation management is secret. It constitutes a commercial secret. So it's not investment into innovation like they tried to tell us when they were drafting the act. No, it is like an Mason's secret. No one is supposed to know about it, and no one does know about the Economic Partnerships Act. Now, under this new article, you have to mention the existence of the agreement. Also, there's a step aside from the proportionality principle. We believed it was an obvious principle, but Mr. Voloshin said it belongs to the 19th century. We believed that if you contribute 1/3 to the charter capital, you're entitled to 1/3 in profits or in losses. You can contribute 100,000 and you 2 pennies, but you have all of the profits for you 2 pennies, and I am entitled to losses for my 100,000. Why? Because that is what we agreed about. Why did we agree about that? Because we are 2 private owners, and we are entitled to the freedom of contract.
And that's the agreement which we have on partnerships. And now we can use it for other corporations. And so we're following American law, that is substituting corporate law for contractual law, because corporate law has imperative norms, which is a norm, and but a dispositive or discretionary norm should be contained in contractual law. That is where we are moving, actually. So, as to partnership agreement and corporation management agreement may be considered thoroughly, but I have no time for this. So, what should be stressed is that any third party can participate in management, and secretly, based on the notary's agreement. And based on this agreement, it may be anything like banks, investment banks, or perhaps some top-level bureaucrats, or even terrorists, God save us all, or those who are involved in money laundering, so no restrictions whatsoever. So in the new reviewed edition, we can now see that only those who are recognized by law as having interest, that's the only restriction, because it excludes terrorists or money launderers. Though we did not succeed in it at once, so we had a lot of discussion. So otherwise it would have been any third party without investing anything in the charter capital, without risking anything, may be involved in the management of the corporation, so total management even. So that's what we agreed upon, and nobody knows about it, with the exception of the parts to the agreement. But now they say that all the parties to the agreement should be there. But in 67.2, the law lays down any participant, and we may be unaware of who or what he is, those who are not parties to the agreement. So that's what we understand as freedom of contract. So one of the central points which a new regulation focuses on, is something that I have a very vague idea of, because I'd like to share my own suspicions about the Ministry of Economics. At the very late stage, when we lost hope of seeing the new chapter. So the chapter went to the State and Law Department of Presidential Administration, where they worked on it without having any advice and counseling from anybody. So today we have the result of this work, that is that the legal entities representation may be based on the article of the code, and the corporation proper is an organization which has a general meeting. In the joint stock company, the shareholder may demand excluding another shareholder, though he has paid for his share. But if he is not to the liking of another shareholder, he may be excluded, as if it were a society of, some communist party or anything. So no comment. The same goes for legal entities list and many other shortcomings of the law that I can enumerate, but we believe that the code should contain the closed list of legal entities. There may be no other entities which are not envisaged by the code. But then the list was extended, and now we have such legal entities which I don't know how to translate into English. For example, 2 new types of non-commercial corporations, which are Cossacks, also the communities of small peoples of the north. I have nothing against Cossacks, but this is a non-governmental public organization, but they said no, that's a new form of legal entity, like the community of small peoples of the north. And now we have new types of economic corporations. These are economic partnerships, and another form are public corporations. And the first versions of the law have already discussed, and these public legal corporations are mentioned in the new code. So I think that's an attempt to retain state corporations. You know that we have 5 of them. The Olympstroy will be done away with soon, and plus another one, Russian roads. So the other will be retained, and the Ministry of Economic Development decided to call them public corporations, unitary corporations. And among new types of corporations, entrepreneurial corporations, now we have peasants' farms. So they may be legal entities, or they may be just nothing. So I'm not going to comment on them, on the peasants' farms or farming enterprises. So as far as unitary enterprises are concerned, well, they are non-existent elsewhere. Even in East Europe, they've been done away with, even in CIS. Well, they are non-existent, like in Armenia, for example. Okay, let them stay. But after Chapter 4 was introduced, we should not create new unitary enterprises, but now the reservation has been done away with, and now they will emerge. And besides, they also become joint stock companies, like the Federal Unitary Enterprise Russian Post, and Goznak is another one. So, but this is under the presidential decree. They will be joint stock companies with 100% state share or interest. So why should we retain them at all? I cannot understand it. But I can guess. I have guesses. Certainly, it's not that bad, because there are very useful norms as well. And they have been adopted because the Ministry of Economic Development was not interested in them. Cooperatives, as you know, emerged in Britain, but they vanished, as well as in the United States, and that is why we can write anything about the cooperatives as the Ministry of Economic Development are not interested in them at all. Also, there's an Institute of Restoring Cooperative Control, and well, quite a lot of useful things. Also, the limited liability companies have been retained, but there are always reservations to all of them. It says if not prescribed otherwise by the law. And certainly changes will be prepared again by the Ministry of Economic Development. They will fix the minimum capital at 20 kopecks because nothing prevents them from that. And there are many other strange things that evaded even the Ministry of Economic Development, so thus the draft is very contradictory. There are a lot of useful things in it, but there are also many strange things which do not fit in as far as the system goes, and I don't know how they will be implemented at all. Instead of considering those norms, which are contained in Chapter 4 of the Civil Code, we would rather consider the former provisions. Well, I'm looking at the architecture, the old architecture. Well, it's more expiring than our Civil Codes, Chapter 4. Thank you. So, very briefly, we can take 3 questions. Anyone would like to put a question? Artem Georgievich. Well, I'd like to put my question. I'm Shitkina Irina from Lower Department of Moscow University. So, what should be done? Article 53 refers to 172.2 as far as representation goes. So how is the system to develop? Because the previous tranche envisaged various grounds for the deals, but there are various bodies now which function on the basis of the charter, etc. Well, you know, I can have guesses because I received the text, and when I looked through it, well, I did not feel at ease. I can guess where it was born from the GPU. Even Minister of Economic Development could not think of such a fantasy. Even economists could not well, invent it. I don't know how we will go about it. Certainly, the legal entities, bodies, are independent subjects and should act on their own. But I think that we should change the law on legal entities registration, because the German law says that we never consider who acts on behalf of a legal entity. We take the excerpt from the register, and that's it. And we also have a potential for this. And our German colleagues requested at a meeting, why not to create a joint venture in Russia where there will be 2 directors, a Russian and a German director will have 50%, why not? So now we have it, we envisage this potential. So we should register it like this, not Mr. Sidorov who should give the power of attorney, but there should be an entity on behalf of which he can conclude deals up to 1 million, for example. This is one of the options, but the question should be channeled to our lawmakers. and they should work as our satirical writer Zvanetsky said, that you should work more specifically and carefully, and not like this, when you just submit the text and then raise emotions. Artyom Georgievich, please take a microphone. So, since we started questions, I'd like to raise a follow-up question. So if the company has two directors and the new law envisages that they act either jointly or each on his own, so what's your opinion? Do you see any problem in that if the charter has it that up to a certain limit each of them can act independently, but at a certain threshold there should be two signatures in two cases? Yes, that's a common thing in the International Arbitration Court, for example, which I participated in, like a joint venture with Aeroflot, and there were two directors, a German director and a Russian director, and they could conclude deals up to a certain limit, and beyond the limit they should have joint consent, or they can challenge the deal. So anything will be appropriate if it is registered and it is publicly open and reliable. Thank you. Any more questions? The last question, please. Vsevolod Baybak, could you comment on the problem of two self-excluding deals when two directors conclude deals which contradict each other? So they're mutually excluding, so they are in a way contradicting. There should be a court suit, and you should be more careful choosing directors. I participated in such disputes, so that's a mistake you made when you selected the directors. That's it. So a short comment for Yegor. All three questions are interrelated. So the representation rule. So what will be changed? Practically, currently we have overcome the practice of point 3, Article 182, because the arbitration court hesitated for a long time, and then they had a case which was a kind of a solution to it. Now we have point 1, Article 183, so unauthorized deals by unauthorized persons. So the point 1 was not used, was not applicable now. It means that it will become applicable. I think that it will be rather useful, perhaps, because unauthorized persons are very numerous now, even directors and all kinds of fake deals. Now they're not responsible at all. They're not accountable. If they are false directors, for example, if it's criminal liability, that's a different thing. But in terms of civil liability, they are not accountable. As to point 1 of the article, he will be threatened with severe consequences. So the representation rule can certainly contribute to it, because I trust two persons and they can conclude the same deal differently with two different outcomes. So this should be addressed. But in corporate law, I have never seen in any source the discussion of the issue, because we never had the rule of two signatures. But in publications dealing with representatives, there are certain hints to it. So there may be various situations. So if a deal precedes the other, then, well, perhaps one will be considered valid, or perhaps both of them, or that's a matter of lack of information or lack of coordination. But counterparties should not suffer. So I think that there's potential for future actions. But in terms of theory, well, it's useful.
I think it's a discussion really, but indeed what we need to think about is that if you ever presided a court or were a judge and you would have two attorneys and the general director, two lawyers, then you as a judge need to really study the letters of authority and proxy of those attorneys and the statutory documents and the founding documents. But now you are facing facing special powers an attorney, letter of attorney from the participants in the litigation. Professor Varol, a short remark if I may. Andrei Vladimirovich, about the bodies of representation. Andrei Vladimirovich, you yourself mentioned that you now cover this principle and that principle by practice, but we still have 183. Perhaps we need to provide some clarifications and comments on that. The practice is okay with that, but why would we fully change the law then? I just wanted to mention that the chairman of the Higher Court of Arbitration at one of the most recent sessions said, would it be the last session really? And I said yes. Andrei Vladimirovich, maybe later, maybe in the evening you can discuss that. Let me give the floor to Professor Varol, a person who knows both our past and our present and would be able to discuss what is the practice in Europe and here. Good afternoon, dear colleagues. Perhaps we need to switch to more general questions and such more general questions are probably less interesting than more specific ones, but my subject to discuss is the model rules and their significance for modern legislation. So what are these model rules and what would be the content and significance for the civil legislation of any country, including of Russia, of the Russian Federation. The broadening economic cooperation in Europe make grounds for attempts in this or other way to unify the laws of the European states, which in turn would help economic integration. The main method of legal unification in the European Union would be directives, which member states must assume. And through such directives, only a small part of the private law has been unified, and this is mostly about consumer law. And I don't think that this really has much significance, because the prevailing politics now is that you need to protect consumers, and this is done through very complex regulation rules, which no one probably would be able to read. However, the additional method of protection in the attempts to unify private law would be the compilation of the so-called model laws. The most important of them would be the principles of European contract law, PCL, that was the first model law in place, the principles of international commercial contracts, or the unilateral principles, and the most novel and expensive model law would be the draft common framework references. Again, sort of like model rules, which were translated into Russian and published in 2013. I should say that this is basically deserves some broad interest in Russia. Since late last century, the past 10 years, during the last decade of the last century, the so-called Commission for the Development of a European Civil Code has been working. The idea was to develop this European code of mandatory laws. The Commission was represented by member states, by professors of civil laws. Basically, we're talking about academics which wanted to trace the progress and development path of the European law. In the UK and in Scandinavia, there was some mistrust towards such civil laws because nothing was unified there. So the European Commission, which mandated the work of the Commission for the Development of the European Civil Law, really wanted to change the name of such model rules and changed it into the common framework rules. But again, we're talking still about the model rules of the European private law. Such model rules contain both rules and norms and include 10 books. The first 3 books, common provisions, common frames, which is again the reworked version of the European contractual law. The European Commission did not really develop this part itself, but rather charged the Commission to do so. And we're talking about some common principles like the right to make contracts, the validity of deals, interpretation, etc., etc. The books from number 4 to 10 would contain some special provisions. The book 4 is the biggest one, which really sets out some model contracts for individual agreements, sale, rent and lease services, loans, etc. Books 5 to 7 are any outside the contract commitments, some responsibility for damages, and etc., etc. And the main contents of the model rules would be common provisions, general provisions, and special provisions. Again, we're talking about such specific provisions of the European Code. There are some specific provisions about trusts, etc. In addition to such model rules, the model legislation includes some central principles, the rationality, the disposition, etc. Probably the key one is the good faith principle, a standard of behavior which specifies the openness of parties to a contract. Well, the definition of this good faith cannot be provided. It is easier to describe what is not good faith. The good faith principle really has some double meaning. First, in the execution of subjective rights and in the execution of legal commitments and liabilities. That is, in broadening the contents and the essence of liabilities. And this is done through two methods, through specific norms, which are based on the good faith principle, and through general principles, which is used in executing subjective rights. The good faith principle, when it is used as the foundation for any specific norm, this principle becomes one of the fundamental principles in lawmaking. Jura stars boni et aqui. If you remember the Roman law, that is, the law is the art of good faith and justice. From the point of view of law enforcement, we can understand this better if we really express this good faith principle through a specific norm, and then we can interpret such norms. It is more difficult to apply this general principle when we don't have any specific norm. The legal meaning of this good faith general principle is that in the event that the rights are executed and the rights and liabilities contradict the good faith principle, which is drawn from a law or contract, then we still need to proceed and use as the basis of our actions the good faith principle. And this is the foundation of the good faith principle in private law. It is not really behaving good, but this is the objective principle that if we are talking about some contradiction with the good faith principle, then the law is not applicable anymore. And hence a question, what would that mean to rely upon the good faith principle, leaving aside the laws and contracts? So we're talking about new rules then. Rules that would exclude injustice and too much harm and damage to one of the parties. And the practice need to fill this good faith principle with enough cases. The use of good faith principle as the general principle also contains some big risks. By leaving this a law and a contract without application, we can harm the legal sustainability of society. It's one thing when the persons, parties, would then not really be sure that their rights and would be protected, because the other party would claim that the said rights would contradict the good faith principle. So we need to provide for a balanced application of the good faith principle, which is important per se, but we cannot really do too much to harm the legal sustainability. And again, the main path should be directed by court practice, and the good faith principle can be applied only when we have some good, reliable legal system, court system, and then can you apply this good faith principle. Otherwise, it might be quite dangerous. And I can say that this is a beautiful principle to be applied, but yes, it is a good one, but also it is dangerous. The principle of disposition, again, or discretion, it's not really about the essence of this principle. We all know that in accordance with this principle, the parties can agree otherwise as compared to what is established by law. And it is important then to see how this principle can be restricted. Would it be restricted in favor of the weaker party, for example, the consumer or the lessor or the employer? Could it be restricted in a sense that it is bound by the good faith principle? As Professor Sukhanov mentioned, that this freedom of contract means that we agreed and that's it. But if such contracts concluded on the principle of discretion and everything is correct, but we still see that the rights of one party run against the good faith principle, then the good faith principle is this restriction or the reason for restricting this principle of the freedom of making contracts and discretion. However, this principle I'm talking about has a narrower meaning through the principle of reason. You need to take into account the time for the execution of commitments, the method and characteristics of would it be the amount, the result, or anything else. And that is about principles. Now, just coming back to the this Commission for the Model Rules and Laws, I can say that the idea, and actually I've been part of this commission for 8 years, and part of our secret wish was that the European Union would have some uniform civil code. But of course, this is unrealistic. This is probably some professor's dream. And of course, this is unrealistic. So some individual rules would mean that the states can use them at their discretion as a model to complement their national legislations. And through this, we can unify civil legislations, which would also in turn help economic integration, that the country would get some good inspiration, perhaps amend the national legislations. However, the interests of different countries do differ, and the countries with the so-called old systems, like in Germany or France or the UK and other countries, the introduction of any changes is difficult because the system is in place and has been being established for quite a long time, and it is difficult to introduce any changes or amendments. It is probably interesting but difficult. However, in the countries which are only in the beginning of establishing new civil law, the amendments made by model laws is favorable. In Estonia, when in the 90s, a new civil legislation was put in place, we broadly used unilateral norms and the European contractual norms, and the model law was not available back then. Although the model law was developed by the EU member states, they don't have any political content. I would say that this is the intellectual product, the result of the work of a group of professors, of academics. And this product is intellectual indeed, which reflects the modern civil legal thought, and this is also good then for those countries who are not members of the European Union and for the countries who are beyond Europe. It's commonplace that if you have parties to a contract from different countries, the parties would agree on the use and application of the law of one particular state, which provides preferences to one side, to one party of the country. But if you use some neutral law, like model rules as applied, the parties to such a contract would be in equal situation. The model rules were presented by the European Commission, but it was not clear what happens next. Based on model rules, the Commission wanted to...
Based on what they received, the Commission decided to create common European sales law. It was a model law, and actually it's a fragment of model laws. The idea was to help the parties choose the law they wanted, and they could decide what to choose based on their agreement. And also it was possible to choose the law, neutral law, if both parties or one of the parties is not a member of the European Union. So it was designed for agreements or contracts where one party is a consumer, small or medium-sized business. Here we speak about sales agreements, electronic sales agreements. And of course, it is not clear what is going to happen to CSL, what new European Parliament will decide, because they're going to continue to focus on that. And it may well happen that this project will remain being just one fragment of a series of laws, or maybe the initial idea will be implemented and CSL will be developed into a law used by the parties based on their agreement. CSL will be used precisely for what DCFR were designed. If the pilot project is successful, then other model laws will apply to other areas like services. The model laws were commonly and widely discussed at numerous conferences and brought about discussions by scholars. It is good anyway, because it helps develop civil law thought and civil law theory, and that will probably result into improving the laws, developing judicial practice, and it is also good because it is related to the first two problems mentioned by Professor Makovskiy. The first being the subject and the second the system of civil law. Thank you very much. Well then, are there any questions of Professor Varul? But you know, if you have questions about the principle of good faith, then Lydia Mikheva is going to speak about the same. So if you have those questions, the two of them will be able to handle them. If you have different questions, you may ask them now. No questions? Then I'd like to give the floor to the next speaker. Before I do that, I'll just say a couple of words. You know, the first and the second part of the Civil Code, almost 1,000 articles were created the first back in 1994, and at that time we couldn't use European principles or model laws at the time when our civil code was created. It's just by way of information. Please, Lydia, thank you very much. Good afternoon, and let me make just a couple of comments about the principle of good faith in the context of the first results of Russian civil law modernization. But I'm not going to speak about the principle of good faith described by Professor Varul, because what he meant was conduct standard, and the synonyms are here integrity, respect of each other, etc. The meaning I put into the principle of good faith is slightly different, and it is more subjective than objective. Good faith that I'm going to speak about has the meaning reflected in the civil code. The words did not know and was not expected to know, could not know about the defects of the transaction, about the collateral, about encumberments, about... So before somebody made a legally significant decision, this person did not know and could not be expected to know. Let me tell you up front that I have not studied this issue in depth, and I'm sorry to say that modern Russian post-reform academic literature writes very little about that issue. Very little, and this division of approaches to this concept, division into subjective and objective meanings, that is what Mr. Yegorov explained in his article in a very understandable way. And he said it has to do with the poverty of our legal language more than anything else. So let me take it back and focus on this relationship, connection between the principle of good faith and what we refer to as cautiousness, carefulness, and then link it to the standards of professional conduct which are being developed as we speak. Based on my very limited experience since the 1st of March 2013, and that is the date when the latest version of Article 1 and Article 10 of the Civil Code were introduced. So based on my limited experience, I may tell you that the introduction of the principle of good faith did not impress broad circles of lawyers, did not impress the legal profession as a whole. Unfortunately and regretfully, the lawyers who work every day but who do not deal with transactions which are worth millions, so moderate level lawyers kind of ignore this principle. They perceive this principle as something written on paper. That's all. And it's not a good thing, because we know that very often people don't read first chapters of the code or the law. They look at the table of contents, they look for something they need, and that's what they're guided for. They don't even, very often they don't even see that it is now different in the different context of the law. That's why I believe it is necessary to emphasize and discuss the consequences of some of the changes that were introduced in the definition of the principle of good faith, because those changes have translated into tangible results. And in the near future, you know that Article 10 has a provision about presumed good faith. And maybe this presumption of good faith will be a breakthrough in our legal life, and there are some indications that we're living through this breakthrough. I invite all of you to believe that ill faith can result in a refusal to protect rights. Well, now, like I said, we have presumed good faith. We have good faith as a founding principle. We have subjective good faith, which has been introduced into a whole number of provisions. And we have some actual consequences and future potential consequences. What are actual consequences of all those changes? Actual consequences include what is going on in the area of government registers. That is something that we can see on the market today. We see some indications of changes. Article 8.1 of the Civil Code, which was introduced on the 1st of March 2003, provides that government registers containing information about property rights shall be deemed as reliable. Unfortunately, practice very often shows different. Sometimes information in the register conflicts with reality. But Article 8.1 declares presumption of reliability and allows us to rely on the reliability of government register every time you want to make a legally significant step. The article is very clear. A person registered in a government register shall be deemed a right holder unless otherwise established in a court. So the lawmaker kind of sends us this message: believe and trust the register, because it's A, reliable, and number two, it's government based. We have to believe and trust in the register because of another principle in the law, the principle of verification. The registers are not databases, they're not data banks. Information may only be included in the register after the information to be included there has been verified. So we have to believe in what is written there. Practically speaking, all of the provisions I have described to you right now mean that the buyers of real estate on the market don't want to know anything in addition to what is written in the government register. We see how this information gathering process goes down into history, where people were looking for prior information about prior owners, about potential claims which may be filed by prior owners. As we read this article and compare it to the presumption of good faith and reliability of the register, all purchasers, all buyers say, I don't want to know anything excessive. Much knowledge means much pain. To buy real estate, what is sufficient for me is to know what is included in the register. A similar approach can be found in Article 51 of the Civil Code, which communicates the same idea to us, even though it's defined differently. It is probably worded better. A person which relies in good faith on the information included in the government register can assume that the information there is actual. Yes, you have this register, it's owned by the government, it's reliable, it's credible, you may believe it. That's why when the previous speaker was talking about the CEO responsibilities, practically it means that if you want to enter into a transaction with a certain company, you can get into the register, look at the CEO's name, see that this person is there, and not look for anything else. It will be an appropriate approach because of Article 74 of the Civil Code. You don't have to read the charter of this company. Of course, there are exceptions from every rule, and quite justifiably, Article 51 and Article 8.1 have wording where ill faith cannot be masked by the government register, because if actually you have information different than what is included in the government register, and you knew about potential defects of the transaction, you are an ill-faced buyer. That was my contribution about the registers. Let me give you two more brief examples. I'll try to be brief, and they will probably push us to think more about it. We have a new rule in Article 189 of the Civil Code, the rule which is not appreciated by the country, which is not a good thing. Article 189 says that if you issue a letter of attorney and you want to make it void, cancel it, then the best way to do it is to send a notification in a newspaper which publishes information about bankruptcy. You want to make this information public, and for that it has to be published in a newspaper. But this publication will be made most beneficial if you read the law. Third parties are deemed to be advised of the cancellation of the letter of attorney 30 days after the publication, if they were not advised before that. I went to the website of Kommersant, went to the link, information about letter of attorney cancellations. I have found several announcements there. Isketim Cement hereby notifies about the cancellation of 20 letters of attorney issued to, and there's a list of people. I'm convinced that none of you is aware that Isketim Cement cancelled or revoked 20 letters of attorney de facto. You know nothing about it, but the Civil Code says that you know about it because you were advised of it a month after the publication. The publication was made in March, so you're presumed as somebody knowing about those revocations. Of course, it's a bold step, which I suggest that we discuss and try to compare that to other similar resources or registers, which are numerous these days. And this is different than the notary information system, which will become operational on the 1st of July 2014, and that will have information about letters of attorney and the revocations, but those will be publications with restricted access. Another rule about collateral and security of real estate. It's a pretty complicated provision, and a lot of civil law experts are afraid that it may not be used appropriately in real life. You know that in this country we don't have a government system of registration, security or collateral registration. We just record notifications of security holders. How is it different than a register? It's not a register. It's not a government register. It's not a register, not even a register. It's just a system of information, and it doesn't meet the standard of reliability. Why? Because the notary who receives this information and posts it on the data bank, they don't verify the information. They rely on the presumption of good faith of every person who brings information to them. So after the 1st of July, you can come to every notary and you may say, you know that my neighbor's apartment has been collateralized for me, and the notary will have to publish this information, include this information in the system. The notary will not be testing your information because the notary will rely on your presumed good faith. My colleagues, when we discussed making the system non-government, we discussed legal consequences of making this information public, and I realized that my colleagues did not even suspect what kind of legal consequences we might have to deal with. It says that the collateral holder, in his or her relations with third parties, can make reference to the right of collateral after the notice was made. Well, does it mean that third parties have been advised of this security? The answer was positive. They said yes. The drafter said, yes, at least that's what we wanted. That's what we are looking for. Every third party is deemed as knowing about the security if this information is included in this online resource. It's an internet-based resource, and after the 1st of July, you can look at whether your real estate is used as security or your debt as real estate is used as security. Guarantee. Another remark. What comes to mind is my colleague from the presidential administration who got in trouble. She bought a used automobile on the secondary market, and then the bank filed a suit against her. After several months in court, she lost the car because the bank recovered the car as a security. The court didn't discuss the issue of good faith. They didn't ask whether she was supposed to know that this car was used as a security for a bank deal. I'm horrified even to think what approach will be taken by the court after we start having databases about cars, railway cars full of grain used as security, which will be included in the database. Can it be that the court could have said, look, buddy, but you can get on the internet and find your car on the internet. Why did you have to buy it? And of course, that's very serious. Article 352 of the Civil Code has a side note. It has to do with a good faith buyer. It says that if you have a good faith buyer and the person could not know and was not expected to know that this item was used as a security, but what is meant by was not expected to know if the access to this internet resource is free? I could use more examples. I'd like to mention one, Article 149.5, which has a very interesting new possibility to publish important information in official mass media. Let me try to summarize some conclusions which seem to be quite obvious. Number one, what is reasonable cautiousness? That is something to think about. Formally speaking, there isn't, there may not be any responsibility to read all open access registers and all other open access information resources. We're just beginning to introduce such a responsibility for notaries only, and I believe it is quite fair.
And all the resources should be verified before.
И удостоверить наше волеизъявление. Но мы-то, стороны этой сделки, обязаны.
But we as parties to the deal, we should be doing it or not. Are we pressurized to do so? Because this is a kind of an obligation that would be imposed on us. So another thing that we should discuss, what's the importance of the registers and covered resources? Because if there's a general approach which is formed, then we can say that the information available there creates knowledge in each third party. Then, as far as non-governmental resources are concerned, so databases, etc., they should be discussed. And it's not by chance that point 1, Article 60 of the Civil Code, which will become effective as of 1st September this year. The legal entity under the reorganization process should not notify each creditor personally, but it makes public the information in the social network, which is sufficient, and which means that this will do. And the administration management insisted on adding another norm. So in the cases envisaged by law, there should be personal information. You should inform by letter, in the form of a letter, though it is available in the net. Certainly, we will encounter a number of other problems, and among them is the legal importance of open resources and data in the age of general informatization or digitalization and access. And I could cite an example. Commenting the voluntary principle at various conferences, my colleague, Oleg Vladimirovich, always cites an example with Swiss watches. So you can buy them anywhere, underground, crossing, open market, etc. So, and any court may conclude that the buyer is not of good faith because the salesman did not look like a known or very expensive Swiss watch. And considering a website of a company producing Swiss watches, I found a resource called the Register of Lost and Stolen Watches. And the company says that the register is created based on the applications from any anonymous person. So, for example, if you want to buy my watch, no, it's a Swiss watch, yes. I can sell it to you. You can see the number on the watch. You can look up the register and find it, and get the information that someone will stated that his watch had been stolen, let's say, and the product could be stolen even if it's not on the register, because the company does not guarantee that the watch is owned even though it's not on the register by a good faith person. So I wonder if the court would demand from us not only to be cautious as far as the circumstances in which we conclude the deal or buy the watch, but also go to the website and they would say, you have an access to the internet. You could have opened the website and you could have known that the watch had been stolen. Thus, did not know and could not know. These words are replaced by did not know and should not have known. So if a colleague of mine spoke here in my place, who is well aware in law, he would say that the expenses on preventing the loss of watch would be greater than those I mentioned here, and just to look through all the information resources and so on and so forth. So I'd like to emphasize that the new rules and norms, approaches contained in the Civil Code, they set the general tasks before us, and not only for Russian law, but also for other legal assistants which encounter similar problems. I think that we should address them applying a common approach, a general approach, without keeping in mind the fact that in each Swiss chalet there is an access to internet. But in the Altai and Kemerovo region in Siberia, there may be problems with internet access, and in particular to the collaterals register. Thank you for your attention. Sorry for keeping you longer than I was supposed to. I understand that good faith is a very controversial issue. 3 short questions and 3 short answers. Andrei Vladimirovich, wait a minute. So, just commentary. So tell me, please, how can we implement our rights? Just to go to the notary and say that my flat is collateralized. How can we do it as of 1st June this year? So collateral for real estate will be registered in the single state register of rights to real estate. It is Rosyeres, the state-owned agency that is involved in it. As far as all the other types of property are concerned, then the lawmaker decided that it was necessary to create a system of recording the collateral system arranged by the notaries. So now you can fill in a form, and the notary won't ask you for the original of the contract or for any other documents which confirm that there is an automobile, that it's existent in reality. But he would look up the resource and see that your automobile was collateralized for 20 years. The idea is rather, well, contradictory and perhaps not as good as it may seem, because there are shortages, certainly. But those who were advocates of the system, they say that thus we can make all third parties aware of this. And this awareness is important, and the notary proceeds from the presumption of truth, so you cannot lie. That is why you're telling the truth, and he loads all the information in the resources based on what you say. Well, use a microphone, because without a microphone there's no translation. Well, as far as I understand, this is only one of the questions that will arise, because the notary's office is involved in it. And certainly the questions are justified and grounded. So I'd like to give an answer to Lydia, whether we are bound to look up the register if something is used as a collateral. No, we are not bound to do it, but we are facing the risk of negative consequences because we have not looked up the register. I think that the problem is somewhat different. First, we have not regulated the issue of description of our property in the register. If the lawmakers consider the draft common framework of reference, which Paul mentioned, they would see how many norms deal with the regulation of the issue. How can it be described? Because anything is collateralized, all the property is collateralized in the country. How can it be described? And what does the collateral holder need? He needs property. As a collateral holder, what should I do to search the register and in order to find out whether the property was used as a collateral? So you can look it up as a collateral, as a subject of collateral, and by personalities. But there's a lot of work. So you can have your search by the register's number and by the person who gives collateral. But there are also traffic numbers and so on. But they say that the registered number that is needed. And the data, I think that this is a great problem. Well, we are not among those who support it all. Colleagues, of late, discussing the problem, we hear that we can differentiate the subjects of civil law. So there are professionals having internet access, having legal services, and they must look up and search all the registers and services. But there may be a grandmother at home, no amateur. Well, it's not her duty to look it up and to search. So this is a conclusion which we can come to after the discussion, and it is very dangerous. Now, all are equal, and that is why the liability is common for all. No more questions now. Then, well, here's one more. Hello. As far as I remember, the Civil Code will contain a norm in 2015 for a collateral of the whole property of a legal entity. So, for example, I come to the shop, I buy a fridge, and I know that all the property, all the fridges, I use as collateral. I know that in Germany this collateral cannot be used for the entire property. You know, this was a matter of very heated discussions in the administration of the president when we finalized the task. And it was a fridge, exactly. And they mentioned the fridge more than once. Because our feeling is that the 352 article says that acquiring the subject of the collateral by a person who is unaware of the collateral, then it comes to an end and the project will be free of any collateral. And we believe that our approach is quite grounded, and it's a way out of the situation. But those colleagues who insist on a comprehensive nature of register, they say no. For all third parties, it is accessible. All third parties could have looked through it, which is very dangerous for retail trade. We had another proposal, because there were a number of options. We wanted 339 article to include it. It contains a rule of an abstract description of the collateral. And in this case, the consumer should be involved. But we lost the battle last autumn. Well, a matter of norms of collateral pledges should be discussed separately. But there's another problem. How can the entire property be pledged? And how does it correspond to the other types, pledge of movable property, real estate, and etc.? If it is not covered by the norm, then, well, it's no use. Otherwise, we should comply with all special norms, and your fridge will come under the pledge or collateral of the consumer goods. So, we've come to an end. Now, I'd like to give the floor to a colleague of ours with an interesting presentation, because half of our civil code is formed as a criminal code which is used by courts. Please, well, there should be translation. Thank you for an excellent translation. So if I am too fast, just stop me. So. Now I start my presentation. Ready? So, first of all, I'd like to thank you all for the invitation to speak here. When I got the invitation, I was in Italy. And when I came to know about the topic, I recalled Giuseppe Lampedusa and his novel Leopard. And in particular, when he says that everything changes and everything should change in order to remain as it used to be, when I'm looking through the windows and see the Hermitage building, an excellent building, and I think that this statement is true. And the same goes for legislation and for the changes in the legislation. So after this introduction, we should start thinking about serious things, not only about jokes. As judges, we should take into account the methodology and the theory of legal norms. So, when the parliaments make laws, as the colleague always says, there's a lot of skepticism in law involved because they are making haste and which are not very specific, vague, and so on. So the Americans say, and they have said it more than once, that if you see two things at a time, you should discern, well, for example, in food production, the sausages are produced and laws are produced, but these are two different things. And lack of knowledge of dogmatism certainly is important. So that's my apprehensions. So I'd like to touch upon certain aspects in the perspective of a judge. So as far as modernization of legislation is concerned and other points.
Before now, we have discussed very important things about methods of modernizing legislation through parliamentary initiatives, but in Europe and Germany, we can say that at least quite recently we adopted very important laws about consumer protection. The law which goes back to an EU directive about the action of the European Union. A very modern piece of legislation and all modern forms of retail trade are taken account of, for example, online trading, etc. Such laws are necessary for the economic changes that are happening in society would be reflected in laws. Because we are saying about new situations, about new opportunities. And of course, the fathers of such legislation and the founders of such legislation, of course, knew about this. And it was important for the new technological state of society to be reflected in laws. What could be the disputes, what could be the consequences for the consumers and buyers when you send some goods back, who would be paying for the sending of such goods back. And of course, some of the things are not of colossal interest to lawmakers, but still we see that if you look at the money which is paid for the postage back of the goods that you don't like, we're talking about big money. We are talking about consumer protection, but about an interesting legal case. And we're not saying that you're only sending, say, I don't know, shoes or something cheap back, but sometimes you are sending back electronics and expensive items. If I don't like some something, I have to send it back out with payment out of my pocket. Or perhaps I should avoid buying anything online and go to a proper store, look at furniture or electronics, and decide whether I like the goods or not. But then we still need such laws, and the laws would be required in future as well. And I think that with the economic development, we might expect more and more cases like this. However, such laws are not really systemically or systematically reviewed. We are referring back to EU directives, and in the European countries we have a diversity of countries, new countries with very young legislations, or older countries like Germany with its 100-year-old civil code. So merging those into one or integrating them without problems is challenging. But let me discuss with you 2 or 3 other areas of modernizing civil legislation. In Germany, whole aspects were reworded, like family law, and we now see a totally new landscape about family relationships, about relationships between spouses and their care about children. And indeed, we are talking about a very substantive and all-encompassing process which covered a whole broad legal field. Every couple of decades you would see some changes there, not every couple of years, like in the consumer protection legislation. Apparently, any aspects or individuals affected by such changes simply sometimes don't know about such changes or cannot really understand them. There's another aspect which perhaps you know or may not. The lawyers who do nothing during the day but look into the newspapers and advertisements, whether those advertisements are correct or not, and if there are any mistakes, the producers would receive letters from such lawyers that you made this and that mistake, or there's something wrong about your advertisement which you should correct, or we can help you for €1,000 to do the same. But still, we do have such a cohort of lawyers, and they do nothing but writing such letters. And I think that this can be explained by the fact that people affected by legislation simply don't know what and which they should refer to in their advertisements to escape any damage suits. And even if you know how to read law, sometimes you don't know how to interpret this or that provision or definition. In this sense, we see that the lawmakers are acting in the interests of consumers, but simultaneously they create problems for consumers. And it's not only about big businesses, but also about small and medium-sized enterprises. And such SMEs have to invite legal counsel for their operations. And another form of of renewing legislation or modernizing civil legislation is that we need to remember the professionalism of courts. I'd say that the courts had to invent whole fields of legislation and starting from the scratch. For example, interpreting a norm, say paragraph 138, according to which any deals which are not compatible with good faith are not admissible. This has always been the case, but still our definition of good faith changes. And to give you another example, when I started my training, it was understandable back then that a contract with an unmarried couple that they can share a room and rent a room would not be compatible with the morals. I mean, if you come to a hotel and you claim you're not married, you won't be given a room in the hotel. The hoteliers could have sent you away only a few decades ago, and now, of course, the case is totally different. Today, nobody would ask you whether you are married if you want to have a hotel room. Today, quite the opposite. If an unmarried couple comes to a hotel and ask for a room, then that couple can sue the hotel for the bellboy, for the receptionist who denied a hotel room, a cheaper hotel room to that couple, and that couple would go to a five-star hotel, get an expensive room, and file a suit for the difference. So you see, the situation totally changes from black to white and from white to black. The very concept and understanding of law changed, and the practice changed. And there are lots of such examples, but this example that I gave is very illustrative, I would say. But of course there are many others like this. I'll give you another example where actually courts went even further. There is a case reviewed by the Federal Supreme Court of Germany, and this is about all cases by the general provisions of contracts. There are very clear rules how to formulate in words such as general provisions, but legislation leaves no other option but to really provide even more detailed descriptions of those provisions and include those provisions into all laws. Another example, which I also started quite at length, was about the responsibility of doctors. If there are any problems with treatment, our legislation provided only for two norms: contractual relations between the doctor and the patient, so whoever defaults on the contractual obligations had to pay. And another one is the damage, willful damage, and out of those two norms, the Supreme Court of Germany developed a whole system of legal consequences of different situations, which describe in detail when we see the responsibility of doctors, how do you treat to various fines and damages, how to differentiate diagnostics mistakes and treatment mistakes, how do you deal with the risks that could have been dealt with, could have been avoided, but otherwise happened. For example, manageable risks. If you had a nurse, a big one, a strong man, and that nurse would be taking an old lady in the hospital, then the old lady would not, stumble or break something. And then, of course, if you have such a strong man as attending as a nurse, then you won't have this. You won't be risking litigation against the lack of care for the old patients. And so on and so forth. Early this year, a law was adopted about protecting the interests of patients and doctors, and I think that this is a very interesting piece of legislation. And to conclude, I can say that the Supreme Court of Germany and the European Court for Human Rights also reviewed the practice, but to some extent both of those courts, if they would really be looking into the interests of the patients and the consumers, especially for the children born from unmarried couples. Some of the things would be unconstitutional, running against Article 6 of the Constitution, so we are talking about the human rights. And the subject that is very popular in Germany when you are talking about homosexuals or lesbian couples, in most of the European countries, they are equal to a conventional marriage. And courts have made frequent decisions when the same-sex marriages and couples would have the same equal rights to traditional families in adopting children, for example. And this is something really for the national legislators to take into account. Sometimes courts cause changes in legislation, not the vice versa. If you look at the practice, then sometimes circumstances dictate changes, and I can accept that, but for that we need very well-educated judges with very good knowledge who act not only out of their discretion, sympathies, or otherwise, but they also follow the good faith principle and would be dogmatically applying legal provisions. So the developments that I was talking about would sometimes become in conflict with legal provisions. Well, thank you very much for this very interesting presentation, which reminds us that a court, in essence, must be also a source of law. But we don't always pay attention to this, and the legal norms, even in Soviet times, that were the result of court practice, were better norms than those that originated from parliaments. So I'm sorry for having to take some more time to give the floor now to Mr. Yegorov, who is one of the authors of the Civil Code, who is really knowledgeable in the practice of civil law application. So perhaps we can fit into 15 minutes of our discussion.
Good afternoon, ladies and gentlemen. I decided to focus on a very narrow subject, specifically designed for a presentation, because the subject of this roundtable is global. It has to do with the results of modernization, but this reform has done a lot of things. It introduced the principle of good faith and some other big things, and something else that has been achieved by the reform is not as visible or seemingly significant. But I would discourage you to perceive them as such. I'm going to speak about Articles 133, 133.1 and 134. The drafting group headed up by Mr. Yakovlev, whose responsibility it was to develop amendments, had heated and lengthy discussions. Very often we realized that people don't understand what complicated provisions are, what indivisible provisions are, and how they correlate to each other. The judicial practice has identified a lot of weaknesses, like in real estate. For example, when you lease out ventilation, then it's built into a building, and then the leasing company stops receiving payments and they want the equipment back after the equipment is built, is part of the building. And now we come across a question about whether this equipment is now part of the building. The biggest question is that if something is an integral part of something else, the rules to this, the rights to this something cease to be. And the High Commercial Court heard a case about the doors which were used as a security. They were built into a building, and then the manufacturer decided to get them back. And then the court ruled that those doors are no longer independent items. They're part of the building. So we have to realize what we deal with. Do we deal with an independent item or part of something else, something bigger? That has a big significance from the point of view of turnover, stability, income, lease, etc. When we got back to Articles 133 and 134, we realized that the language was pretty vague, and that resulted in problems with application of those provisions. The reform introduced clarity into that, into what constitutes complicated things and what constitutes indivisible things. Complicated is not an item, it's more than one thing, it's many things. Like 10 cups, it's a set of cups. They sell it to you in a single box. While it is in the single box, well, it is perceived as one item, but actually it has 6 cups, 6 saucers, etc., and they are individual objects. Just for the sake of simplicity, they are sold as one item. Still, you can imagine a situation where the husband and wife will decide that deeper dishes go to the husband and smaller dishes go to the wife. You can imagine such a situation easily. And in this situation, it will be quite clear whose dish was broken as a result of a fight. But in this situation, it is easy who should be responsible for what and how you can recover those items. It's complicated. It's a set of china, but it consists of 18 different items, for example, and you can use one dish as a security or collateral. Of course, it's a simple example. It's much more difficult when you deal with equipment or locks on the windows in this room. Are those locks independent items or are they parts of the window? Article 133 of the Civil Code gives you a definition of a constituent part of an item. In the past, it was used in the context of composite items. Now, composite items are defined as a set of individual items which are brought together in a composite item. As for indivisible items, the decision was made that if you have an item which you cannot divide unless you destroy it, and which is used as a single object of individual rights, shall be deemed as indivisible. This bottle is an indivisible item. You can take it apart into two parts. I can pour water out of it. But it is indivisible. We deal with a single item, and that is really critical. It is not very often that we come across this issue in real life or have come across it. While in Germany or in Switzerland, when you have a manufacturer, suppose I'm a manufacturer of this mineral water, and I have to buy glass bottles from my vendor. My vendor provides the glass bottle, and they have a clause that they retain the title before I pay them. So I pour water into the bottle, I sell the bottles, and still I have not paid the vendor. So what do I have? A combination of three different things? A cap, bottle, and water, or is it one indivisible item? The doctrine of this indivisible thing, even though this thing physically consists of other parts, shall be deemed as a single indivisible item for legal purposes, and you can recover it as such. That is critical, and I expect our judicial practice to develop, and I'm sure that this example with doors will go down into the annals of history, and in the future we'll be dealing with something more essential. This improvement of the indivisible item area will, I believe, help us very much, and will get some of the rules back that were part of the Roman law. When you combine two different things, you take somebody's log and use it in building a new house. And of course, that should be the subject of the right in things, or things in Rem. And one last, most recent thing that we have had is that we have this rule of a single real estate site. It consists of two different ideas, whereby individual buildings can be registered as a single real estate site, even though the distance between them may be 100 meters. It may be, for example, an oil well pumping oil, a pipeline, and a storage, oil storage. It may be registered as a single site, and then it will be made impossible. It will be impossible for you to buy 2 meters of the pipe, right? Because it's a single site, and then you may become a monopoly and will not give access to the pipe. And we have lots of examples like that. In Sahar, there was a high-profile case because in the process of privatization, the tank was held by one person, the pump by somebody else, and the pipeline connecting the two by still somebody else. And now we can take care of such potential conflicts, registering those three items as a single thing, as a single system. But you can go even further. The buildings may be located in different lots of land owned by different people, so potentially you may have other problems. But as long as a building is an independent item of real estate, it is separated from land, and we already have such a potential problem. There was an attempt made to introduce a rule of a single object and to say that it is only a plot of land that may be deemed as an individual and indivisible unit of property, and everything else can be divisible. But they decided to not to use it. There is another thing. If I have a plot of land and I have three different buildings, I don't have to have every building registered independently. I don't have to have 4 different transactions if I sell my land with the buildings. Building 1, building 2, building 3, and land. I can just sell my land, but the buyer will realize that it will have a bathhouse, a race house, or a hut for horses, and a residential building. Horses are okay. Horses are no longer luxury for many people. So here you have an opportunity to create what we expect to have in the future. You have only land, and what you have on this land characterizes this land. Maybe somebody has an oak tree which is 600 years old, which is much more expensive than a small house which is on a similar plot of land owned by a neighbor. Those are some individual thoughts, because we can discuss it for a long time on end. You can use crops as security before the harvest, or you can use bushes as a security. Maybe believe that if they included in the balance sheet, those bushes are used as a separate independent item, even though it is part of the land, and you cannot have individual rights to blackcurrant bush. So hopefully this reform will bring us closer, or will bring us back, depending on the point of view, to the European legislation, and it will probably have a very positive effect. That is what I wanted to share with you. Thank you. One very brief question. May I? Andrei. A seat in a car, is it part of real estate? My answer is going to be long. Please don't give me any answer. You know, I'm confused about what was proposed and what we developed. I believed that premises, objects, items of civil law relations, but we lost it. Yeah, we just lost it. As for the car seat, it doesn't have any limits. Oh no, you mean a space where you park your car. It's just 1 square on the land. And once again, we should look at the Western experience. We may criticize it, but the parking space in Germany is the same as parking space in Switzerland and in Russia. Cars which come to Russia are the same cars as in Germany, even though the climate is colder, but they ride. You can drive it. And just like premises are something fictitious, you just agree to perceive it as an item. The same goes for parking space. They agree that those 18 square meters on the floor, which have long time markings, that is an item of real estate. And then virtually they imagine limits for this real estate. What happens to the land? You have a small plot of land and a fence, and virtually you can imagine the limits of this plot. Very well, thank you. Thank you all. I'd like to thank our speakers above all for exciting presentations. There's one thing I would like to point out to you. I want you to keep in mind this broad array of different issues and problems described for your sake. Window locks, parking space, abstract principle of good faith. That's what we do. It's part of our legal profession, and we have to focus on that. Let's work hard. Let's try to create good laws. Thank you.